All right, this next lecture is on land use restrictions that arise from claims of nuisance. A private nuisance is a non-trespassory invasion of another's interest in the private use and enjoyment of land. Key elements here are that it's not trespass, okay? So there is no trespassing over the property. Now, this differs from a public nuisance, where with a public nuisance, there is improper interference with a right that is common to the public. Both cases that we're going to go over are private nuisance cases. So the elements of private nuisance claims are that the act needs to be intentional. It needs to be non-trespassory. It needs to be unreasonable. It needs to substantially interfere or substantial interference with the use and enjoyment of land. Use and enjoyment of land. Boomer v. Atlantic Cement Co. is a classic case of private nuisance, and it's used in your textbook to illustrate two parts of nuisance law. The first is the traditional gravity of harm test, right? The gravity of harm test. And the second is there's a long discussion of what is the appropriate remedy for nuisance. The facts are as follows. Atlantic Cement operated a large plant that made cement near Albany, New York, and it employed 300 people, and they had invested more than $45 million in the plant. Boomer and other neighboring landowners complained that it was a private nuisance because it emitted dirt, smoke, and vibration, and that these emissions injured their properties. So the trial court found for the plaintiffs, but they refused to issue an injunction. Instead, they awarded the plaintiffs compensatory damages for past injuries suffered, and then they insisted that the plaintiffs could bring future actions for additional damages that they would continue to suffer. The trial court found that just for the guidance of the parties, the total estimated amount of permanent damage would be $185,000. This ruling was affirmed by the Intermediate Appellate Court, and it was also affirmed in the New York Court of Appeals decision that is in the textbook. So the issues at the center of this case are whether or not there was a private nuisance, and if there was, what was the appropriate remedy? The court, like I said, spends most of its analysis discussing the appropriate remedy, but I'd like to take a moment for us to go through what facts there are to see if we think that all the elements have been met to find a private nuisance. So the first element is intentional, right? So based on the facts, do you think that the problem was intentional? Well, to determine whether or not the act was intentional, we look to two things. If they knew that that there was a continued act, and they continued it after they knew about the harm. So there's knowledge of the harm and continuation of the act after the knowledge of the harm. And in this case, we would have met that because the plaintiffs complained about the problem before they sued, and Atlantic continued to emit the dust, smoke, and vibrations, right? So the first element of intentional would have been met. The second element, non-trespassory. So interestingly enough, we might think that dust trespasses over the land because it's a particle that flies over the land, but for historic reasons, English courts have long held that dust or dirt that comes over the land is a non-trespassory. It is non-trespassory. So in this case, we would meet the requirements for non-trespassory. The question is whether or not the conduct was unreasonable. So here the court, although they don't specifically say this, they appear to use the traditional gravity of harm test. And under the gravity of harm test, they look to the harm that had occurred. So $185,000 worth of property damages would be sufficiently grave harm to be an unreasonable conduct, right? And that's quite a bit of harm to property. All right, fourth element, substantial. The dust, based on the facts that we have, it appears that the dust and the nuisance was an appreciable invasion of the plaintiff's interests, right? It did significantly seem to bother them, right? So it would be a substantial harm. And here, courts would look to see, does it interfere with their enjoyment or their use of the land? I would argue yes. So the fifth element is use and enjoyment of the land. Again, we don't have a ton of facts here, but we did have some facts about the dust causing some damage to some personal property, and some of the vibrations damaged one of the homes. So I think there's sufficient facts to find that it interfered with the use and enjoyment of the land. All right, so they have a case for nuisance, right? The question then becomes, what is the appropriate remedy? Now, this analysis, let's go through the analysis, and then we'll talk about what exactly you need to know for exam purposes. So the rule before the Boomer case in New York was that if there was nuisance, which we said that nuisance has been found, and there has been substantial damage that can be shown, then an injunction would be granted. So applying that test, the court agrees that they should have issued a permanent injunction. However, the court decided to deviate from that rule here. And they decided to deviate in part because although the nuisance was large, the defendant had invested $45 million in the cement plant and, perhaps more importantly, employed 300 people there. So any permanent injunction that required the factory to close would have caused some substantial economic loss. And so the court, they had more than one option here, right? They could have enjoined the nuisance, which meant a permanent injunction here. They could award permanent damages and then allow the continued operation of the plant if the damages are paid. Or they could award temporary damages and then allow the continued operation. But that would put the burden on the plaintiff to continue returning to court as they incur more damages. The court decided to grant an injunction, but that injunction would be vacated upon payment by the defendant of such amounts of permanent damage. So they granted the injunction here, but they allowed for that injunction, but they postponed the date of effectiveness for that injunction to allow time for the cement or the plant to come up with a solution, a technical innovation that would address the current dust problem. So they kind of gave them a hard deadline with the risk of closure if that deadline hadn't been met. All right, so what do you need to know for your exam about remedies and nuisance claims? Well, you need to know that there are two common types of remedies sought. One is money damages, and the second are injunctions to enjoin the defendants from continuing that harmful behavior. That's what you need to know. And that's it for that case. All right. We're going to skip over this thought question, and we're going to go on to the next case, Thompson v. Grieve, which I think does a little bit of a better job of exploring the elements for private nuisance. So the facts of this case are that in 1990, the Thompsons moved into a home that was 15 feet from the Graves home. And the Graves home primarily heated their home using a wood-burning stove. In 1992, the Thompsons complained to the Graves about the smell that came from wood burning. And there was conflicting evidence in front of the court about the severity of the problem. The trial court found that the smoke to be a nuisance. The Court of Appeals affirmed this, but amended the trial court's judgment by awarding $4,000 in damages and directing the Graves to stop the behavior that caused the smoking, right? So in this case, this was a appeal of an equity action, which meant that the factual questions were being tried de novo here. So the question was there a private nuisance? And so just so you can see, this is what the smoke looked like coming from the Graves house going to the Thompsons' house. So the court states the rule, which is, one is subject to liability for a private nuisance if, but only if, his conduct is a legal cause of an invasion of another's interest in the private use and enjoyment of land, and the invasion is intentional and unreasonable. Intentional and unreasonable. So the first question the court was considering is, what did unreasonable mean, right? What was unreasonable harm here? And the court says that the intentional invasion of another's interest in the use and enjoyment of land is unreasonable if the gravity of harm outweighs the utility of the actor's conduct. The court then spells out various examples or factors to consider when looking to determine the gravity of harm, and factors to consider when looking to determine utility. And we're going to go through each of these elements to see how the facts of the case supported these particular factors. So let's start with gravity of harm. Gravity of harm. So if you look on page 798 and 799, the court quotes the sections of the restatement that we're referring to right now. And they say, gravity of harm, when you're looking at gravity of harm, you should consider the following factors. A, the extent of the harm involved. B, the character of the harm involved. C, the social value that the law attaches to the type of use or enjoyment invaded. D, the suitability of the particular use or enjoyment invaded to the character of the locality. And E, the burden on the person harmed of avoiding the harm. All right, so let's start with the first, A, the extent of the harm involved. So in this case, there was some conflicting evidence about the extent of the harm, right? So there were Ms. Thompson testified that smoke caused her minor health problems, but there were other witnesses that said that the problem wasn't very severe, it just smelled like wood burning. It's kind of difficult to understand this balancing test unless you try to give it a 10-point scale. So if we gave it a 10-point scale here, we might say that the extent of the harm involved would be a 4 or a 5, right? Out of 10. Okay, so we keep going on through the rest of the factors. The second is the character of the harm involved. So the character of the harm here was occasional, and it caused personal discomfort and some inability to use the land. So it didn't cause any serious personal injury or any damage to the property, however. So we'd probably rate it lower on this scale, maybe give it a 3 or 4 instead. Then we go to the next element, or factor. The social value that the law attaches to the type of use or enjoyment invaded. So there's high social value in allowing people to be able to use their home. And so the social value of the Thompsons' ability, or their ability to use their home, we'd probably rate that pretty high, like an 8 or a 9. I'll explain to you what we'll do with all these numbers in a little bit. So then we go to D, the factor, the suitability of the particular use or enjoyment invaded to the character of the locality. So here, this is a residential neighborhood. And so their use, the Thompsons' use, was suitable for their locality. So we give that, like a 10, right? Pretty high. And then E, the burden on the person harmed of avoiding the harm. So here we'd look to that the Thompsons, they could have avoided the problem by simply closing their windows. Now, that's not a really high burden, at least I don't think so. The court said that they shouldn't be required to do this, but if we think about it realistically, the burden on the person harmed of avoiding the harm, if all they needed to do was close their windows to stop smelling the smoke occasionally when they smelled it, I would say that's a 3 or a 4, right? As far as the gravity of the harm goes. So if we average out all those scores that we just gave them for the gravity of the harm, that gives us a score of about 6. Okay. So then let's compare that average score with the score that we're going to come up with by weighting the utility factors. Now again, this idea of adding the number scale just helps us do the weighting. But for exam purposes, you are just going to need to argue, for bar purposes, you'll just need to argue one way or the other. But this might help you make up your mind, right? All right, so let's talk about the factors that go into consideration when you're looking at the utility of the conduct. So the first factor is the social value that the law attaches to the primary purpose of the conduct. So the primary purpose of the Graves conduct would be to heat their home, and generally that would get a pretty high social value. But then this is about specifically using a wood-burning stove to heat the home, not just heating the home. And the court also points out that the stove does emit lots of smell and it saves on fossil fuels, but the foul smelling smoke doesn't benefit society, right? So probably rate the social value of a wood stove in particular at a 2. The suitability of the conduct to the character of the locality. The used stove would definitely be useful in a rural area, right, where homes are far apart. But this actually didn't occur in a rural home. This occurred in a subdivision where homes are only about 15 feet apart. So is it suitable conduct for the character of the locality? Not really, right? That's pretty close together. So we'll probably rate the suitability of the conduct between a 2 or a 3. All right. Third factor, the impracticability of preventing or avoiding the invasions. The Greaves actually had another form of heating for their house, and that was to use electric baseboard heat. And the comment to the restatement notes that if an invasion can be practically avoided in a way that's not prohibitively expensive or harmful, then it should be. So under that standard, the impracticability of preventing the invasion is pretty low, right? Perhaps here a 2. So now let's compare the average for the factors under utility with those of the harm rating. So we said the harm rating was a 6, and the average of the 3 utility ratings is about a 2. Now, again, this is a very imprecise system that we're using here, but if we look at our rating, then we would argue that the gravity of the harm seems to outweigh the utility of the conduct. And so based on that analysis, the Greaves conduct was unreasonable. Let's do some hypotheticals where we can further explore the restatement rule. So here we're looking to see if nuisance exists in the situation below under the gravity of the harm test. And then we're also looking under the restatement standard, and if so, we're going to talk about what remedy is most appropriate. Oops. First hypothetical. 2 months ago, Church A opened a shelter for the homeless on its property, which is surrounded by single-family homes. About 15 homeless people sleep, eat, and live there each day. Since the shelter opened, many neighbors have found litter in their yards. Burglaries have occurred at 5 homes. Inebriated shelter residents have scared small children on 3 occasions, and everyone in the neighborhood is worried. An appraiser estimates that the shelter has lowered the value of adjacent property by 2%. Does a nuisance exist on either of the situations below? In this situation. Let's start with the gravity of harm test. Under the gravity of harm test, the neighbors would lose because they don't really have a cause of action here. The problems of litter, scared children, general worry about safety of neighborhoods is a part of everyday life. And although there have been 5 burglaries that have occurred since the homeless shelter opened, there is no statement about how many crimes occurred before that, right? There's no causation here. We don't know that that it is because of or but for, right? And property values rise and fall over time, and a 2% drop in property value is a very small decrease. And so that slight value would not make it a nuisance. What about under the restatement standard? Well, under the restatement standard, we would consider the utility of the shelter as well as looking at the gravity of the harm. And here, the utility of the shelter, so we already have harm that's not very substantial. The gravity of the harm is not very substantial. And when you add in utility, considerations of utility, then it is even more likely that the neighbors would not have a claim of nuisance. And that is it for nuisance. That concludes the chapter on land use restriction as well.